Hi everyone, and thank you for joining us at the Legal HR Summit. The Legal HR Summit is a two-day online event hosted by Jus Laboris, the largest employment law alliance in the world. This session is part of the Asia bloc and will be followed by other curated sessions of the region. I am then turning over to Sujang Lee to begin this session. Go ahead, Sujang, you can start.
Thank you very much, Annie, for your kind introduction. Hello, everyone. I am Sujang Lee. I'm a partner and head of international labor practice at Yurchon, a full-service law firm in South Korea. We are in a region where countries have acted decisively and very quickly to deal with COVID-19. But despite these efforts, the pandemic has inflicted very heavy economic damages on the region. Companies are trying to come up with ways to cope with this crisis, and understanding the legal restrictions on what you can or cannot do in the countries you operate will help you to prepare for and implement restructuring or right-sizing, however you call it. You will hear from my panelists, distinguished panelists, all labor law experts from countries like China, Japan, Thailand, and New Zealand, how you can navigate these challenges and find the right directions. So before we begin, let's do a short poll to see how many countries are represented by this audience group. And you will share a polling question and you can vote for which countries you're responsible or are interested in. So let's take a couple of seconds. Well, since this is really a question that don't really need a lot of thinking, should we just close the poll and see the results? Oh, very interesting. So we have other as the popular choice, and it looks like it's a good representation by all countries, and we are very, very grateful for this opportunity to talk about this restructuring with you, a very timely and important topic. So now I will turn to these experts group here, starting with China, New Zealand, Japan, and Thailand. So Tracy, can you start with a brief explanation on the current situation in China, how COVID is, and what you're advising on the restructuring in your country?
Well, sure. Thanks, Suyang. Hello, everyone. This is Tracy Zhu from Fangda Partners, a China-based international law firm. I am a counsel of the labor and employment team of the firm. It is a pleasure to have this opportunity to be part of this interesting summit and to share with you China views. So may we have the slides to be alive? Thanks, Annie. Please, next page. Well, things in China have been back to normal in general since around 3 and 4 months ago. Businesses recover quite well, and people have been returning to work at the office for several months after COVID-19 is controlled. Well, we personally haven't received any clients' query relating to COVID-19 since the same time, which also indicates that the whole situation in China is going well. Although because of reopening of the border, we do have some imported cases occasionally. Annie, may we go to the next page, please? So for the legal framework, the general framework on restructuring or redundancy under Chinese law does not change due to COVID-19. As a fundamental legal principle, redundancy or termination of employment should be made based on one or more statutory grounds under Chinese law. That is, termination at will without any cause is not allowed. However, COVID-19 does not fall within the scope of statutory grounds for redundancy or termination. If restructuring will lead to job elimination and redundancy becomes necessary as a result, this situation may be regarded as one of the statutory grounds for termination called a major change of the employment contract, which makes both parties unable to continue to perform the contract. Certain legal process must be followed by the employer for redundancy or termination made due to a major change. Failure to follow any of such process may render the redundancy decision insufficient or invalid. To be more specific on the process, the employer should firstly negotiate with the affected employee to try to amend the employment contract, which in most cases is achieved by offering an alternative position within the company. The alternative position offered should be suitable for the employee's skills and expertise. The purpose of this step is to give the employee the opportunity to continue employment with the employer before the redundancy has to be made. If both parties cannot reach an agreement on the amendment, then the employer could terminate the employment by providing a 30-day notice or 1 month salary payment in lieu of the notice, and then paying the statutory severance. The statutory severance is the minimum statutory compensation that should be made, which is basically 1 month salary for each full year of service with the company. Lastly, at the same time or immediately after redundancy decision is made, the employer should also issue a notification to the union to inform the redundancy decision. This step is for information purpose only, because the union has no right to veto the redundancy decision. Okay, that's for China. Now I will pass on to Scott from New Zealand.
Good afternoon, everyone from New Zealand. And thanks, Tracy. My name's Scott Worthy. I'm a senior associate at Kylie Thompson Caisley in Auckland, New Zealand. Kylie Thompson Caisley is a boutique employment law firm, and we deal with all aspects of workplace law in New Zealand, including employment law, immigration, and health and safety. In terms of COVID-19 in New Zealand, it is well controlled at the present time. We have 4 alert levels in place. We are at alert level 1, which means that COVID-19 is controlled, but we should be ready in case it reappears in our community. There is no current community transmission, and businesses and schools, hospitals, organizations are open as normal, but our borders are closed. New Zealanders can return home and quarantine, but it's very difficult to come to New Zealand if you're not a New Zealander. Next slide, please. The key message that the New Zealand government has been very keen to make is that there is no change to our statutory framework for redundancy in New Zealand on the basis of COVID-19. All the same rules continue to apply. That doesn't mean that COVID-19 cannot be a reason for a redundancy, but all the normal procedures and safeguards are still in place. The first important safeguard is that the employer needs a genuine business reason for making an employee redundant. That reason must relate to the business and not to the employee, him or herself. redundancy can't be a way of getting rid of a particular employee because of performance issues, for example. So the employer will have to explain in detail what that business rationale is. And it's not enough simply to say that COVID has hit. COVID might be the reason why there has been a loss in demand or a lack of demand for the company's products, or COVID might be the reason why the company needs to be more efficient to cut costs and save money. But a lot of employers are simply saying COVID is the reason we're making you redundant, and that's not enough. You need to connect the COVID, impact of COVID with an impact on the company itself. The next thing an employer must do, and the next safeguard, is to share information about the reason for the proposed redundancy. The obligation is to provide the relevant information to the proposal. That might be financial information, or it might be simply evidence that there has been a big decline in demand, although of course most employees will probably be able to guess that themselves. The next safeguard is that there must be full and fair consultation with the employee. So in the end, the employer has the ability to make the decision about whether someone is redundant or not. But before making that decision, the employer has to consult with the employee. Consultation doesn't mean agreement, but it does mean explaining to the employee the genuine business reason, sharing relevant information, and asking for employee feedback. The employer should then consider that feedback and potentially amend its proposal, or if it decides to go ahead, it will have to explain why it is still going ahead and what it thinks about the employee's feedback. So the focus is on the process that the employer undertakes so that the employee can make sure that it is making a good decision in the genuine interests of the company. And the employee has some input into that decision, although doesn't get to make the final decision on that, have the final say. And the last point there is about redeployment and selection. As we've heard, perhaps with Tracy, in China, there is an obligation to redeploy someone if there is a vacant role somewhere else in the business that you know that person can perform. It's also important to be careful about the selection process, and so that if there is a situation where employee numbers are being reduced, the decision about which employee is terminated and which employee remains is justifiable and on the basis of a selection criteria that you have set out in advance and asked the employee about. So with all that in mind, that's an update from New Zealand, and I'd like to hand over to my colleague from Japan, Nobuhito.
Hi, Scott. Thank you very much. I'm Nobuhito Sawasaki, an employment partner of Anderson Mori Tomotsune. Anderson Mori Tomotsune is the second largest law firm in Japan, providing multiple areas of services, including employment and labor matters. From now, I'd like to explain COVID-19 situation Japan first. The graph on the slide shows the number of people who tested positive PCR in Japan on a daily basis. The first infection wave lasted from March to May. At the end of May, the spread of the infection slowed down. However, the number of infected people increased again in July and peaked in August. There are few infected people now than in August, currently about 700 to 800 people a day. However, the number of infected people is projected to increase again in winter. In April, Japanese government declared a state of emergency. During this period, the government requested people in Japan to refrain from some business activities and other personal activities, such as traveling within the country. Although these requests were not legally binding, they were relatively well respected given the culture in Japan. Currently, there are no more infected people than in April and May. There are more infected people than in April and May, but there is no declaration of emergency. The government requires thorough measures to prevent infection, but residents are essentially free to engage economic activities in their daily lives. You can eat in restaurants, you can go to the movies, you can also travel within the country. Japanese government appears to have taken this soft approach after considering that a true lockdown like a European country, it would have had a significant impact on the Japanese economy. Entry into Japan was restricted through September. However, as of October 1st, the conditions for every entry have been relaxed, and entry for business purposes now permitted with certain conditions. After entering Japan, a 14-day quarantine is normally required. However, the government has decided to further soften the travel restrictions as of November 1st. After that, a 14-day quarantine is not always required. This is a COVID-19 situation in Japan. So move on to the next topic, redundancy in Japan. When a company is in financial distress, it is often considered reducing the workforce, especially in the case of a non-Japanese company. But in Japan, the dismissal of employee on the grounds that the company business performance is deteriorating is referred to as a dismissal for redundancy, in Japanese, SEIRI KAIRO. According to the established court precedent, in order for dismissal based on the redundancy to be effective, all of the following four requirements must be met. First, there is a significant and reasonable necessity to reduce the workforce. Second, the company must do every effort to avoid dismissal for redundancy, such as cost cutting, before engaging in it. The third one is criteria for selecting the employees to be dismissed must be fair and reasonable. And the last one is the company must undertake discussion in good faith with the relevant employees and the relevant labor unions. And if a company decides to undertake unilateral dismissal, at least 30-day prior notice is required. If a longer notice period is contained in the rules of employment or the individual employment agreement, the company must comply with a longer notice period. Unlike some other jurisdictions, no statutory severance payment is required. As for the filing requirement, a filing to Hello Work is required if 30 or more employees are expected to leave the company through dismissals based on the redundancy. These legal framework of dismissal for redundancy, these are the legal framework of dismissal for redundancy, but there is no change due to the COVID-19. Please note, however, that the outright dismiss, I just explained the requirements for dismissal for redundancy, but that does not mean that outright dismissal is permitted. Rather, I should say that outright dismissal is not permitted, because I have explained the company must show that it has made every effort to avoid dismissal for redundancy, such as cost cutting, before undertaking dismissal for redundancy. So for this reason, before engaging in staff reductions, company commonly carry out steps such as reduction of non-personal expenses, reducing working hours, putting employees on leave of absence, and reducing bonuses and salary. In addition to putting employees on leave of absence, I'd like some comments. When a company puts an employee on a leave of absence, in principle, the company must pay leave compensation to the employee in the amount of at least 60% of the employee's average wage, pursuant to the Labor Standards Act. The company may receive a certain amount of employment adjustment subsidies from the government if it pays leave compensation to employees on leave of absence. And it is said that because of this employment adjustment subsidies, the number of dismissal for redundancy, which has already been undertaken, is not as many as expected. Finally, I'd like to make some comment on the mutual separation. In addition to cost cutting, before undertaking dismissal for redundancy, company must sincerely attempt to terminate employment of targeted employees based on the mutual agreement. If the termination is mutually agreed, basically, there will be no legal risks. For these reasons, it is fairly common that company offers a separation package to targeted employees in exchange for their voluntary termination of employment contract. There are no legal restrictions on the type of separation package that can be offered to employees. But the separation package will usually reflect the contribution made by the employee to the company because for the fairness and the between the employees. That's all my explanation on the redundancy in Japan. So I would like to ask Surin. So Surin, would you explain your home country, Thailand?
Thank you, Nobuhito-san. Hello, everyone. My name is Sulin, and I'm from Rajan Tan's office in Bangkok. Just a few words about our firm. We are a full-service law firm advising on corporate, commercial, regulatory, and litigation matters. Particularly relevant to today, we regularly advise multinational companies and Thai conglomerates on contentious and non-contentious employment matters, including retrenchment, disciplinary proceedings, unfair dismissal proceedings, and we also assist clients in preparing, filing work regulations, reviewing of ESOP plans, etc. On the COVID situation in Thailand, you will see from the slide that as at the end of October, there was a total of 3,759 confirmed cases, of which 815 were infected inbound travelers and local people returning from abroad. We've had relatively low number of fatalities at 59. I think Thailand appears to have managed to manage the spread of the virus well. And I think that comes down largely to closing borders early on. But of course, that takes a toll on the economy, especially in terms of tourism, which accounts for about 20% of it. There are currently still restrictions on inbound travel. And there are 11 categories of people allowed into Thailand at the moment, including Thai citizens, diplomatic staff, holders of work permits and permanent residence permits, non-Thai students, and those married to Thai citizens or parents of Thai citizens. So in addition to falling within that category, you also have to show a health certificate showing a negative COVID result issued not more than 72 hours before travel, and health insurance coverage of at least $100,000 US. On arrival, you will be subject to COVID screening, followed by a 14-day quarantine period at a place designated by the government. The government has also recently started allowing tourists who hold special tourist visas to enter Thailand. These are long stay visas, and they are subject, these tourists are also subject to testing and quarantine requirements. In terms of businesses, almost all types of businesses have been allowed to reopen since September of this year, provided that they take appropriate disease prevention measures. So from a domestic perspective, we are more or less back to normal. And certainly we've been back in the office since June. So, unlike other countries, domestically, I think we're more or less normal. The government has also announced measures and guidelines for the management of the state quarantine facilities and surveillance and investigation of COVID-19, and also guidelines for clinical practice, diagnosis, treatment, and prevention of healthcare-associated infection in response to patients with COVID-19 infection. So that's the situation, current situation for COVID in Thailand. Annie, could you please move to slide 2 for Thailand? So I think the first thing to note here is that Thai employment law is employee friendly, and Thai courts lean to help employees. So the premise to start off is to understand that once you give a benefit or a welfare, it can't be taken away without consent. And the terms and conditions of employment cannot be unilaterally changed by the employer unless they're more favorable to the employee. So there is no specific law or exemption for reducing work hours. I get asked this quite a lot. And so there is no specific law reducing work hours for employees in case the employer's business is affected by COVID-19. So if you wish to reduce normal working hours, you need to obtain consent, and we recommend that consent is obtained in a written format. Similarly, into the case of working hours, if you wish to reduce wages or salaries, you would need to obtain consent, and that should also be in writing. As to redundancy, there is no change to the framework as a result of COVID-19. The employer has to comply with the general requirements and processes under the labor protection laws when terminating employment. In practice, this means that the employer has to first issue a written termination notice, at least one pay period in advance, or a longer period if required under the employment agreement. The employer has a choice to terminate employment right away and have the employee leave by paying salary in lieu of advance notice on the day of termination. In addition to advance notice, the law requires the employer to pay statutory severance payments on termination, and that would include statutory severance pay at rates under the Labour Protection Act, which ranges from between 30 to 400 days of wages, depending on the employee's length of service. And then prorated wages in respect of unused annual leave for the year of termination, and accumulated unused annual leave from the preceding year if the employee has been allowed to carry over the leave, and any other contractual employment entitlements as agreed in the employment agreement. I think I should also say that even if you make all these statutory payments, there is always a risk that the employee will bring an unfair termination claim against the employer in the Labour Court. And if the employee does that, and the Labour Court finds that the termination was unfair, it could award further damages against the employer. So I guess what I'm really saying is that even if you terminate employment and pay full compensation under the Labour Protection Act, an aggressive employee might still lodge a complaint against the employer in the Labour Court and claim damages. The situation is not tested in terms of COVID. So I think, if the business is still being carried out, but you'll do it using different methods in carrying out business, for example, requesting your employees to work from home, then it's unlikely that a termination with full severance pay would be considered by the court as an unfair termination. Based upon several Supreme Court decisions, which are not binding, but only persuasive, termination due to an economic reason or reorganization of an employer's business from the necessity to maintain the business, for example, to decrease costs, would be considered as a fair termination. On top of this, you have to make sure that the procedure for the selection of employees whose employment will be terminated is made fairly, using certain definite criteria, or using same criteria amongst other employees who would be terminated, such as years of service, annual evaluation, grading, or skill and experience. The reasons for termination of employment of the employee should also be set out clearly in the termination letter to minimize subsequent argument that the termination was unfair. If the court makes a finding of unfair termination in the event of a claim in the court, the amount of damages likely to be granted is in the range of 1 to 1.5 months' wages for each complete year of employment. That's on top of the statutory severance pay that the employer would have paid on termination. That's the situation in Thailand, and I will pass back to Soo-jung, who will speak on South Korea. Thank you.
Thank you very much for the explanation, Serlene and everyone. Before we move to the group discussion, let me briefly explain the current situation in South Korea, where I am. like other countries, and as I explained in the intro part, I think in Asia, especially these countries that we are in, we have been very fortunate to that in a sense that the governments have very acted decisively and quickly. So the situations have been relatively managed better than other parts of the world. In Korea, we have a number of cases. The confirmed cases have been fluctuating. We had 2 hits, as you can see in the chart. We had some hits in the early February and March, and another one in November, and recent in September, in August. But aside from these numbers, the practical life has been going on. Personally, there was no single day that I was not in the office except for the weekends or other holidays. Our office, the law firm, has been taking preventive measures of work from home, but there were a lot of attorneys who just decided to come to the office because it was not mandatory. And I was the one in the subway every day and mingling with people. Big gathering is prohibited, and there are certain activities that are not prohibited, but are discouraged to have occurrence. But everyone is wearing masks in everywhere, so people are taking precautions themselves, and things have been going on as much as possible normal, quote unquote. Can we move to the next page, please? In South Korea, like other countries that we have heard today, COVID didn't really change anything about the legal system itself. I heard from my clients saying that Korea is the most difficult country that she has ever experienced in terms of employee termination, and that may still stand true in the COVID situation. So termination possible, our statute provides the basis and the ground and the process, but how much of the authority or discretion the company has, very, very limited. So, and how much of discretion the company has in making any adverse unilateral changes, very, very limited, almost impossible. So like Thailand's case, we cannot make any adverse changes without employees' consent in terms of working hours, salaries, or furlough or temporary shutdown. If you do go through a shutdown because you just have to, then you are still required to pay at least 70% of wages to the employees who are not coming. So you are reducing your cost just a bit, but not much. Business layoffs are subject to the same standard of just cause like in any other termination case. And there are these other statutory safeguards that you have to go through. It's very similar to other countries, but as we learned today, in Japan, you don't have any statutory severance requirement. And in Thailand, the damages can save you. So if you wrongfully terminate, you just pay them as a damages. The critical difference in Korea is it's worse. If you wrongfully terminate somebody, that person comes back. The remedy is reinstatement. You cannot just buy that person back unless you reach a settlement, like separately. So these termination cases have to be approached very carefully and strategically, to say the least. And I think these 5 countries, we are in a more sort of employee-friendly legal regime because we don't have countries like Singapore or Hong Kong in this panelist. If you have those countries, then you would have had a bit different stories from them. And you can continue this webinar because we will have a session on Hong Kong and Singapore and other countries later on. So please keep tuning in to this webinar. Now we have only about 15 minutes left. Let's continue to the second part of this session. We thought that it will be interesting to talk about the practical issues. We are all labor law experts here. And in this year, compared to other years, probably, you've been receiving a lot of inquiries from your clients what can we do basically to go through this crisis? What can we do or not? So I have two questions that I thought that might be interesting to our audience, the HR practitioners and the legal practitioners. The first question to everyone here is, so what has been the most frequently asked question to you in dealing with redundancy issues? And the second question or request is, if you have to choose one single takeaway from this session out of your country, what would that be? So a practical tip for our listeners. So Tracy, you want to take a first?
Sure. Well, for China, I think the most frequently asked question would be, well, we may have to implement a restructuring or redundancy as we suffer economic loss due to COVID. Well, any risks from legal perspective? As I just mentioned, COVID itself is not a statutory ground for redundancy or termination. So like some other countries like New Zealand, Japan, companies in China should also have solid or genuine business background, such as financial data, a change of their organization chart caused by the impact of COVID, etc., to support the needs for restructuring or redundancy. Lack of these sufficient business background may render the redundancy decision illegal, in which case the employees would have the right to claim for either reinstatement of employment like South Korea, or monetary damages amounting at twice the statutory severance. Well, in addition, whether there is any protected employees to be affected should be considered as well. Protected employees are defined as those who are during their mat period, or female employees who are within the maternity or nursing period, etc. They are protected from redundancy due to a major change caused by the COVID. And also, if the number of employees involved is large, there may be also like negative social impact. So I think the company should also consider carefully if a prior communication with the local labor authority to seek their assistance and guidance would be necessary. Thank you. Well, I'm also interested to hear answers from other countries.
Right. Thank you very much, Tracy. The last part was very interesting. We wouldn't necessarily advise our clients to contact the government authority first about your idea unless it involves like a huge union, the regional union.
Right.
But that's very interesting in China. So we have about 7 or 6 minutes only. So let's move to Scott. You want to take the next spot?
Yes, thank you. The biggest issue that potentially is coming up in New Zealand is selection of employees to be made redundant. A lot of people are accepting of the idea that the business needs to make redundancies to save money, but they're saying, I should be selected, I should keep my job, and someone else should lose their job. So it's very important that the employer run a fair selection process, that the people who could be made redundant are asked about the selection criteria first and given the opportunity to give feedback, and then that the employer accurately selects based on the selection criteria, including potentially asking, before a final decision is made, the employees how they have scored, show the employee their score, and say, can you confirm this is all correct? So there's no doubt that the person or the people who score at the bottom of the selection criteria are the appropriate people to be made redundant under the criteria.
Very good. I think those fair selection criteria, I think I heard from everyone actually in your country, you have a similar legal requirement to make sure that the employees are selected fairly. In Korea, that would mean that it's looked not only from the company's perspective, but also from the employee's perspective. So whether that person is sort of self-sufficient to be laid off in terms of whether he has a family to support, etc. Those will be also looked upon as one of the conditions. How about you, Nobuhito? Do you want to share some practical tips? I know you mentioned about, do some mutual termination or mutual separation also. You want to share some tips for the audience?
Yeah, thank you very much. I think in addition to Japan, I think the most important strategy for successful workforce reduction would be to reach a mutual agreement for termination as often as possible, or as many as possible. Because if an employee is unilaterally dismissed, he is likely to file litigation or legal committee proceedings based on the wrongful termination. And these procedures are quite expensive and time-consuming and difficult to win for the employer. However, if the employer is able to terminate employment of the target employee based on mutual agreement, basically there is no such legal risk. And in order to increase the possibility of executing a mutual agreement for termination of employment with target employees, companies should be ready to present strong and justifiable reasons to support dismissal based on the redundancy, and to offer a reasonable severance packages. And also good leader and task schemes are very, very important.
Thank you very much, Nobuhito. Celine, last comment from you?
Yeah, sure. I think position in Thailand is not really that much different from Japan. I think what's important to say is that, I get asked quite often, my business is being severely affected by the COVID crisis. Is it okay for me to use that as a reason for termination? So I think the first thing to say on that is that just using the COVID crisis and the impact of the COVID pandemic doesn't fall within a ground specified under the Labour Protection Act, which exempts the employer from statutory severance pay. So you can do the termination, but you have to remember that it has to be with full compensation, as I mentioned earlier. So I think you need to be aware of what is the actual reason for the termination. Is it, for example, if your business is still being carried out, but you're doing it through different methods, having the employees work from home, for example, and then if you terminate just on that basis, it's quite likely that if the employee brings a claim, that it would be deemed to be unfair. I think you have to be quite careful. So if a termination is made solely for your benefit as the employer, without a sufficient reason, for example, just to reduce costs and to increase profits, believe it or not, some businesses are making profits during this time, then I think the likelihood of an unfair termination finding is quite high. And then, as I said, the risks, in terms, it could be quite expensive for long-term employees. But I would also echo what Nobuhito-san has said, that, where possible, consider holding discussions and persuading the employees or the employee to enter into a mutual separation agreement, which has a waiver and a waiver of claims. I am conscious of the time, so I should hand back to Soo-Jung. Thank you.
Thank you very much. All very useful tips. Same kind of goes to South Korea as well. Because the termination, the hurdle or the standard is so high and very difficult to meet, we often advise clients to reach mutual separation rather than resorting to termination. And in redundancy, in a business termination case in Korean setting, that is the default requirement, because like other countries, we have a requirement to resort to termination as a last resort, but you have to exhaust all the other remedies, which include that paying somebody to leave, basically. So that is indeed a de facto requirement. So we often advise our clients, and our clients do painfully go through that process to achieve what they need to do. So we only had one question from the panel, actually. So I know we have only 1 minute. But the question was, is there a difference in requirements for retrenchment versus redundancy? In Korea, it's the same thing. I mean, we use the different term, of course, in Korean, and retrenchment means redundancy in Korea. It's a business cause termination. I don't know about other countries. If you have a different answers from Japan, Thailand, New Zealand, or China, please write back to this audience after the session. And I'll pass it to Annie for close up. Thank you very much.
Yes, thank you, Su Zhang. We have now reached the end of this session, but the Legal HR Summit is not over yet, as we have many other sessions coming up today. Finally, I would like to thank everyone for attending this session, and thanks also to all of our panelists for their important insights. So with that, this session will now be ending. I hope to see you at the next one.
Thank you very much.